Hey guys, this is Attorney Pandeli. I'm a senior immigration attorney, and I just got out of immigration court, and we had a successful bond hearing for one of our clients. And I just wanted to quickly discuss the basic elements of a bond hearing and what's important to be able to convey to the judge. And so the first and maybe one of the most important elements is what's called danger of flight risk. And so flight risk in essence means that if a judge will give a detainee a bond that they won't be able to return to court. Flight risk doesn't mean that they will leave the country. Flight risk doesn't mean that they'll go in another state or anything like that. But really the definition is that they need to be able to prove at a hearing, whether it's an attorney or the detainee, they need to be able to prove that they will return to court, that in essence they have an incentive to return to court. And so typically incentives are things like, maybe they have a pending petition, maybe they're trying to get their everything in order to stay in the US. In addition to that, so you have flight risk, danger of flight risk, and then there is the prior criminal history and danger to the community. And so danger to the community, what falls under these categories really things like does the detainee have a prior history of not obeying US laws? And so typically if you've had a lot of driving no license or DUIs or worse criminal violations, family violence, battery, or drug charges, they're typically mandatory detention. But you really want to show that the effect of this history is minimal, and if you have any history, you want to minimize the impact of it, and you want to show to the judge that if released, you're not going to be a danger to the community. You're not going to go and commit another offense. Now, if you were already on bond and then you got released and then you go and commit another criminal act, that's going to be a tough case to convince the judge, because they already gave you a shot and you blew it. And then lastly, and this is sometimes underestimated, is really community ties. So community ties in essence is, does the detainee have the requisite relatives in the US, things like US citizen spouse, kids, family, that means that his life is here now, or his life has been here for a long time. Another way to show community ties is, how long someone has been in the country, how they arrived in the country. Oftentimes it's as a child, and really all they've known is this country, and so it's important to note that. And then underneath all of this, when a judge or when you go for a bond hearing, is whether there's a likelihood of success, that if the case goes to fruition, meaning if the case goes to conclusion, that this is not some speculative kind of claim that oftentimes people will have a claim to asylum, but it's based on very very few things, or it's based very on thin ice, in other words. And so if you have a case, whether it's asylum or whether it's you have withholding of removal or withholding under the what's called Convention Against Torture, alternatively, if you have cancellation of removal, having been in the US over 10 years and you have good moral character, or on top of that having some form of adjustment of status through a relative, those are not typically speculative forms of relief, and so you want to show that you have a real shot at staying in the country. So those are some of the requirements. So you have flight risk, danger to the community, community ties, and then lastly that your relief will not be speculative.